Good afternoon, and welcome to the Society for the Rule of Law's webinar on the Equal Rights Amendment. My name is Gregg Nunziata. I am the Executive Director of the Society. If you're not familiar with our organization, I just wanted to say a few words of introduction. The Society is a group of conservative, libertarian, and center-right attorneys and others who share a commitment to the defense of the rule of law, the Constitution, and American democracy above partisan or policy preferences. We try to advance that mission in a range of ways through some targeted advocacy and through thought leadership, symposia, and webinars like we're having today. The Equal Rights Amendment may seem like an esoteric item or a historic footnote, but it's a tremendously rich subject area that folks are passionate about on both sides. But it raises some really fundamental questions about what the Constitution is, how we read it, how we amend it, who gets to decide what it means as a matter of law. So I'm excited to have this conversation today. All of our presentations, including this one, are taped, available at our YouTube channel, which I invite you to go have a look at. You might want to see, we recently had a panel at the Principles First Summit with myself, George Conway, and former Congresswoman Barbara Comstock talking about challenges to the rule of law that the country currently faces. The Society also put out a recent statement on the executive orders targeting law firms, which we will drop a link to in the chat. Uh, I will be speaking, and hopefully there'll be some tape of this, at the Reagan Library this weekend in California at the Federal Society Western Chapters Conference on a debate on how conservatives should advance and protect the rule of law in the current environment. Now we will move on soon to our current panel. A couple of teasers, though. We will soon be announcing a panel on the First Amendment and how it's faring in the Trump administration. Our panelists will be Keith Whittington of Yale Law School, Eugene Volokh, and Robert Corn Revere of FIRE. So that should be a very interesting conversation with three real leaders in the First Amendment field. We also will soon be announcing an event on impoundment and another digging deeper into the executive orders against law firms. Okay, now allow me the privilege of introducing Professor Stephen Sachs of Harvard Law School. We are very proud to have with us today. He is the Antonin Scalia Professor of Law at Harvard. His research focuses on the law and theory of constitutional interpretation and the history and procedure of private law. He has a new article focusing on the Equal Rights Amendment, which is published in the University of Chicago Law Review, fine law review from the law school I attended. We will have a link to that in the chat as well. I will be turning it over to Professor Sachs in a moment. Before I do, wanted to mention that we will be taking questions at the end. If you have questions, just put them in the chat. You don't have to wait till we get to Q&A. I will keep an eye on them and pose them to Professor Sachs when the time has come. And with that, Professor Sachs, welcome and take it away.
Thank you very much for having me, and thank you also for that kind introduction. And thanks to all of you for spending some of your day with us. I will now attempt to share the screen so that we can see our presentation. Okay. So today's talk is about the Equal Rights Amendment and about its current status, which is highly unclear. It is not at all obvious what the Equal Rights Amendment has done, or whether it is part of the law of the land, but we will see. So on January 17th, 2025, shortly before he left office, President Biden announced that the Equal Rights Amendment had cleared all necessary hurdles to be added as the 28th Amendment and that it was the law of the land. This was somewhat surprising to many, in part because nothing had changed in the previous 5 years to suggest that the Equal Rights Amendment had suddenly become the law of the land. During 2020, the additional states had ratified it, but nothing new had occurred. And so it was quite a reversal for President Biden to announce that it was the law of the land in the last few hours of his term. But his statement was welcomed by some. The American Bar Association had announced its view that the ERA was the law of the land, and the American Constitution Society echoed that view, along with many esteemed scholars. So why would there be any dispute about the ERA given that it has been ratified by the legislatures of 38 states? Well, when the ERA was originally proposed in 1972, it had a provision stating that it would add certain text to the Constitution when it was ratified within 7 years of the date of its submission by the Congress. And that did not occur. By 1978, 35 states had ratified. Four states had purported, at least, to rescind their ratifications. I put it in scare quotes there. It's not entirely clear that that works legally, but we'll sort of avoid that issue for the moment. In 1978, Congress purported to extend the deadline in a joint resolution saying, notwithstanding any provision of the original proposal, it would be valid if ratified not later than June 30th, 1982. June 30th, 1982 arrives. The original deadline had already lapsed. The new deadline had lapsed. No additional states had ratified in the interim. And so the ERA was widely thought to be dead. But then a number of states later on decided that they could ratify it. Nevada in 2017, Illinois in 2018, and Virginia in 2020, bringing the number perhaps to 38, the three-fourths required under Article 5. And so the question is posed, had the ERA been validly adopted as part of the Constitution? Now, again, to answer that question fully, one would have to have a view of the status of the rescissions, because not only the original four states, but even a fifth state, upon the lapse of the deadline, purported to rescind its ratification. I am not going to address that today. The best discussion of this is by Michael Stokes Paulson in an article called A General Theory of Article 5, which I commend to all of you. What I'm going to focus on is the within 7 years provision of the proposal of the ERA. And so there are two legal issues here. First, can you have a deadline in a constitutional amendment? And secondly, can it be in the resolution text rather than the text of the article that is proposed to be added? So in the 20th century, both alternatives have been used. In the 18th Amendment, Section 3 stated that the article would be inoperative unless it were ratified within 7 years of submission. And some folks thought that this was unconstitutional. There was a Supreme Court case about it. Supreme Court thought it was fine. We can say more about why it thought so later on. But then this strategy was used for a number of other amendments. So the 20th Amendment, Section 6, had such a provision. The 21st Amendment, Section 3, repealing prohibition, had the same provision. Then in the 22nd Amendment, the same thing. In the 23rd Amendment, a different approach was used. Instead of putting the time limit in the proposed article, the time limit was put in the text of the resolution proposing it. This followed from a suggestion by Professor Noel Dowling of Columbia to Senator Kefauver that we could avoid cluttering up the Constitution with a deadline that would be sort of irrelevant as soon as the amendment either had or had not been ratified. Either it wasn't ratified within 7 years, in which case the deadline wouldn't matter because it wasn't there, or it was ratified, in which case it was part of the Constitution now, and we didn't need to say the deadline in the text of the Constitution. And so Dowling proposed moving the deadline provision to the resolution text. And that was the approach used in the 23rd Amendment, again in the 24th Amendment, which was valid only if ratified within 7 years. In the 25th Amendment, the language was changed slightly to state that it would be valid when ratified within 7 years. So valid at a particular time, which may or may not ever come. The 26th Amendment used the same approach. Then the ERA used that approach. And then another proposal, the DC Voting Rights Amendment that was proposed in 1978, it did both. This was during the discussion of the ERA deadline and whether it could be extended by Congress. So they took no chances. They put it in both the resolution text and in the text of the proposed article. And so the question arises, is any of this valid? Does it have legally operative effect? If it's in the resolution, can it be altered by a future Congress, et cetera? And there's a lot of argument about this, but I think it's useful to look at a page of history. And this is what I try to do in my article, The 12th Amendment and the ERA, forthcoming in the University of Chicago Law Review. And if you'd like to read it, there is a link at stevesachs.com/ERA. That's STEVESACHS.com/ERA. Not to provide some self-promotion there. And the point that I try to show is that Congress has, in fact, used operative text in resolutions proposing amendments. It has made those resolutions legally enforceable in other contexts, in the Bill of Rights, in the 12th Amendment, in the 17th Amendment, and in a wide variety of draft proposals, such that if that approach is inconsistent with Article 5, that would be somewhat surprising because Congress at least hasn't seemed to think so in the 18th, 19th, and 20th centuries. And the overall picture that it suggests is that, in some sense, the resolution is the amendment. Congress gets to decide what change it wants to propose and under what conditions or at what time. And so, by doing so, it can decide whether we are or are not going to add any text to the Constitution. And if that's the right way to think about it, then the ERA is not and can never be a valid addition to the Constitution's text. So let's see briefly what these look like. So Madison's initial draft of the Bill of Rights was not for text that would be added at the end of the Constitution. Instead, he wanted to cut and paste and make edits within the Constitution. So he said that sort of in Article 1, Section 2, Clause 3, strike out these words and add in these words. In Article 3, strike out the following and insert the rest, et cetera, et cetera. That approach was not used in the end. In the end, they decided to add text to the end of the Constitution, but they did so with legally important language in the resolution. So the proposal of the Bill of Rights was not of a package of amendments. Rather, it was for 12 discrete amendments, 11 of which have now been ratified, the first 10 in 1791 and the 11th in 1992 as what is now the 27th Amendment. And so they stated, here are a bunch of amendments, all or any of which articles, when ratified, would become valid as part of the Constitution. And this was important because that language allowed the states to pick and choose which articles they were going to include. Had that not been there, then the House and Senate would have had to agree on a particular list that the states could only give an up or down vote to. Or if the House proposed 12 separate amendments, the Senate might not have gone along with it, and vice versa. So, in order for the House and Senate to agree on the same list, which the states could then pick and choose among, you needed some way of presenting them with that legal choice. And they did that through the text of the proposing resolution that made clear which things they were and were not proposing. A similar approach was taken in a different way a decade later in the 12th Amendment. So here they are revising the mode of electing the president, and they state, in lieu of the third paragraph of the first section of the second article of the Constitution, which was describing the Electoral College process, the following be proposed as an amendment. So they were proposing not just to add new text to the Constitution, but to delete existing text in the Constitution and add something else in its place. This was actually important. They debated this. And part of the reason why they did it was that among the various proposals for changing the Electoral College, some of them did or didn't make cross-reference to the existing constitutional text. And some representatives and senators felt that that was a problem because it would be a little bit unclear after the language had been adopted what was still in force and what had been overridden. And so they said, you know what, the cleanest way to do this is just say, no longer look at that section anymore. That paragraph is gone. Only look at the following text. And then they copy pasted the existing paragraph and made whatever edits they wanted to make to it in the 12th Amendment. So in some sense, this was not sort of all that startling. I mean, we would probably read the 12th Amendment the same way, whether this text is in there or not. But it was very clear that the proposal was not just add the following text to the Constitution. It was add the following text as a replacement for existing text in the Constitution. And so the resolution language specified what kind of legal changes to the Constitution Congress did or didn't want to make. And the states picked up on this. Almost all of the state ratification instruments acknowledged that what they were doing was taking language out of the existing Constitution, or at least removing its legal effect for the existing language, and then adding new language that would override the existing language. The same thing happened a century later in the 17th Amendment. So here we have, in lieu of the first paragraph of Section 3 of Article 1, which describes electing senators, and in lieu of so much of paragraph 2 of the same section as relates to the filling of vacancies. So not chopping out all of that paragraph, but only the parts that relate to vacancies. So the resolution is telling us what parts of the Constitution are no longer operative once the following text is added. And again, the state ratifications almost all mentioned this as what kind of change was being made to the Constitution. A number of proposals acted similarly. So, future President Andrew Johnson in 1851 proposed snipping certain parts and adding other parts so as to make it read as follows, and so on. And this was a very standard approach. And all of that suggests a number of possibilities for constitutional amendment. So, you could propose to add new text, such, we're going to repeal this clause. You could say, not adding any text, but just making an edit to the Constitution. Resolved that the Constitution be amended by repealing Article 6, Clause 3. You could do a hybrid approach in the Andrew Johnson style. Or you could amend the Constitution in a way that doesn't allow for any sort of specific text, that just makes it clear what change is being made. So if we wanted to do the 11th Amendment, instead of adding text at the end, we could have said, just amend the Constitution by not construing it to create jurisdiction in suits of the following kind. And that would presumably have its legal effect. The Article 5 process doesn't say you have to add text. It just says that you can change the Constitution in whatever way Congress proposes and the states ratify. If they really want, they could add their amendments in hieroglyphics if they want, so long as we understand what change is being proposed and what change is being ratified by the states. This means a number of conditions could be done through resolution text rather than article text. So, for instance, we could say, as they did in the 18th Amendment, we're going to add this text with an inoperative clause unless the following condition is satisfied. Or you could say, and if you did so, the text would get added whenever you had two-thirds of each House of Congress and three-fourths of the states. It would just be legally inoperative. It would be as if you had passed an amendment that added the following text: this amendment shall do nothing at all. It adds to the language of the Constitution, but it doesn't change its legal content. The legal content is the same, but the text is different. What the ERA strategy did and what the various sort of resolution text alterations did was specify whether we wanted to make any change to the text of the Constitution in the first place. So if you had said, amend the Constitution by repealing that clause when ratified within 7 years, well, it would only make that change at a particular time, namely when it's ratified within 7 years. And if that time never comes, the text of the Constitution never changes. And it adds that text on condition and not unless or until the condition is met. It is as if Congress proposed to amend the Constitution in the following manner, namely not at all. In that case, you would change neither the text nor the legal content of the Constitution. And that, I think, is the best way to understand what happened with the ERA. It makes a change to the text of the Constitution only when a certain condition is satisfied, and it turns out that that condition never occurred. We could imagine other kinds of conditions being done through resolution text. You could specify the effective date of an amendment that way if you wanted. You could say this amendment's going to be valid 2 years after it's ratified. Sometimes we put that in the text of the amendment, but you could also put it in the resolution text saying we're going to add this language, but only after 2 years after ratification. Or transitional provisions. So when they changed the Senate election process, they said, don't apply this to any existing senator. You could presumably do that through resolution text also. Ultimately, it's the job of the Constitution printers to get right what the current text of the Constitution is and what its legal effect is. It's sort of like the difference between the statutes at large, which is just the sort of all of the amendments and laws passed by Congress, and the U.S. Code, which is a summary of all of the legal content as it currently stands. We're used to thinking of the Constitution more like the U.S. Code. Here's sort of exactly what it is right now. But maybe we ought to be thinking of it more in the statutes large way. Here are all the changes that were made to the original text. And this has some implications. First, there's no real difference between the resolution text and the proposed article text in terms of making changes. It's up to the proposing Congress how it wants to phrase its amendment. The proposed article, the text that it's adding, is in the resolution. So it'd be very strange to suggest that the resolution doesn't have any legal power when that's the only thing adding any text to the Constitution or not. In addition, some resolutions might add text, some might not, and we just need to read each one. We want to know what change to the Constitution is Congress proposing, and it can frame that change any way it wants, so long as it's understood. Other implications are that we don't need to invoke any special time limit power. Supreme Court in Dillon suggested that Congress might have a power to specify the time limit for an amendment. We don't really need to worry about that. Maybe there is one, maybe not. But the proposal in the ERA was conditional. It said only do this when the following condition is satisfied, which has not and never will occur. You couldn't imagine Congress overriding earlier resolution text like in lieu of. They couldn't say that old amendment that was proposed is now going to be in lieu of more things, and we're going to chop more things out of the Constitution without two-thirds of each House and three-fourths of the states agreeing to it. So it'd be very strange to be able to take out a condition from the existing ERA proposal, which suggests that Congress really cannot extend the deadline, whether in 1978 or today. It also suggests that there's no contradiction between the rules of Article 5, which say an amendment is valid once you get two-thirds and three-fourths, and the proposal in the ERA, because it's just specifying what kind of change it wants to make, whether that's a change in the text of an article, inoperative unless ratified by every state, or whether it is the text in a resolution. Ultimately, it would be added to the Constitution's language if you had 38 states, but it would need 50 to actually do anything if that's what the article text said. Same way, the Constitution, even though, it specifies here's how amendments are going to be added, the amendment power is plenary. So it's sometimes argued that Congress can't add conditions because it would be like the famous case of INS versus Chadha, which said that you couldn't provide for a single House veto of a executive action. And the reason for that is that Congress, in enacting legislation, needs to be using its delegated powers. It needs to be adding something that is necessary and proper to executing other powers vested in the United States. But the power under Article 5 is plenary. Congress can propose anything. It could propose to make the United States part of France. It could propose to have a rotating cast of presidents depending on sunspots. It can do whatever it wants under Article 5 if you get two-thirds of each House and three-fourths of states to agree, so long as it doesn't reapportion the Senate. That's the only thing it can't do without unanimous consent. And so, given that this power is plenary, there is no reason to suggest that it is limited by some rule against time limits or some rule that prohibits it from making changes depending on the conditions in the resolution text. So, as a result, it would seem that the condition in the ERA is perfectly legally valid, and that as a result, the ERA, although it went through the Article 5 process and got ratified by proposed by two-thirds of each House and ratified by three-quarters of the states, it did not and cannot add any language to the Constitution and is not the 28th Amendment today. So thank you very much, and I look forward to any questions.
Thank you so much, Professor Sachs. It was a great presentation. It really is a great article. I commend it to everyone, even if you don't make a habit of reading law review articles. This is a fairly concise and article that's really a pleasure to read, even for non-lawyers. So I invite that. The other thing I should mention that I forgot at the top is one more detail about the Society. We are a membership organization. Our members make this programming possible. If you're not yet a member, please consider joining. If you are a member, please let your friends know. There's a link for membership in the chat. Now let me I guess a big picture question on the implications of all this. I'm just going to quote from your introduction to this article. You write that in a deeply divided society in which legal experts already disagree on key questions of constitutional law, losing consensus even as to the content of the Constitution's text can be quite dangerous. Could you expand on that? Sorry, I would. I'm not. You are muted, I believe.
I'm so sorry. One of the most surprising aspects of President Biden's announcement was that it was, in some sense, trying to meme an amendment into the Constitution. So, how do we recognize whether an amendment has been added? There are some sort of official indicia. So, for example, the Archivist of the United States has a statutory duty to publish all amendments. The executive branch presumably has a view about what the Constitution says. If it prints up copies of the Constitution, they say something and not other things. And what was so strange about President Biden's declaration was not only that it seemed totally unprompted by events, because if the ERA is part of the Constitution, it was so on his inauguration day and even before, but it also did not commit the executive branch to the position that he was announcing. He did not instruct the archivist to publish the ERA, as indeed the archivist had agreed as a result of various court challenges not to do. He did not instruct his Office of Legal Counsel to rescind its most recent opinions on the matter, which suggested that the ERA was not yet part of the Constitution of the United States. He did not commit the executive branch to maintaining that the ERA was part of the Constitution. It really just sort of created a great deal of fog as to what the Constitution contains. And you know, in a world where basic propositions of law are hotly contested among different groups in American society, it would be really nice if we at least agreed on what the Constitution said. I could certainly imagine folks trying to create a consensus that the ERA is valid, sort of sotto voce or through, informal means. You can imagine, for instance, the American Constitution Society printing up lots of copies of the Constitution for law students, as it currently does, containing a 28th Amendment. And so it seems important to know, is there such a thing or not? We actually don't want it to be a sort of identification mechanism where people sort of show their fealty to a particular cause by their copy of the Constitution having different things in it than other people's copies. One of the few things the Constitution's text can actually do is get people who disagree about everything else to at least agree on what Constitution we have. And to my mind, you know, that doesn't answer the legal question. It is a legal question whether the 28th Amendment was validly added to the Constitution or not. But if you think it is, you ought to say that in a sort of whole of government, consistent, forthright way. And President Biden did not do that. And I think that that's really quite dangerous, that this is not an area where uncertainty is helpful or where doubt is particularly useful to the polity.
How do you think about, I guess, the president's responsibility to say what the law is? And presumably there's a zone where things are contested. Uh, I don't know if we think or if you think of the current president's position on the 14th Amendment and citizenship falls on one line or the other. But what's a plausible and responsible way for the president to assert interpretation of the Constitution that may not quite fit with settled court precedent or broader understanding?
Right. So Article 2 says it's the president's duty to take care that the laws be faithfully executed. And that means the actual laws. So if the Constitution has a 28th Amendment in it, it would be the duty of the president, because, the ERA states that the United States is limited in certain ways. It would be the duty of the president to acknowledge that and to act according to it. Now, there's a separate question about what do you do about court decisions? And so you could have what's sometimes called the judicial supremacy view, that the Supreme Court is the highest authority in what the Constitution says, and the other branches should always defer. You could have a departmentalist view, which was Lincoln's view after Dred Scott, which was that as to Mr. Dred Scott, yes, the judgment is binding, but as to everyone else, it's the president's job to take care that the laws are faithfully executed. And if they think that Chief Justice Taney got it wrong, they should say so, and they should bring more test cases, and they should sort of act in other ways that are not covered by a judicial judgment. I mean very precisely the judgment as opposed to the opinion. In the way that they think is lawful. And likewise, Congress should act in the way that it thinks is consistent with the actual Constitution, giving whatever deference to the smart people on the court that they might know what they're talking about, but not being bound by them because these are all three co-equal branches. And the implication of that for other areas is that if something is being done forthrightly and honestly, faithfully, as the Constitution says, then that's what the president ought to do. Now, of course, they ought to also get it right. So if the president is wrong about birthright citizenship, then it would be wrong for him to instruct the executive branch to follow an incorrect understanding. If he's right about birthright citizenship, and if Congress has not instructed anything different, my understanding is that the statute just sort of repeats the language of the 14th Amendment, then it would be his duty in executing that statute to follow his best understanding of what the Constitution and the statute provide. So, in some ways, the president acts at his peril. He has to do what he thinks is the right view under the law, and he can't sort of rest on other branches' interpretations necessarily. He's responsible for his own understanding of the Constitution.
And what about the obligations of congressmen? Is it thought of any different? Particularly on the ERA, you have, I don't know, maybe a third of the members of Congress have taken the position that the ERA is the law, maybe for political purposes. But do we think about their obligations to the Constitution differently?
I mean, they take an oath to the Constitution too, so it is their job to, uh, support the Constitution of the United States in a faithful way. And if they believe honestly that the ERA is part of the Constitution, they should say so. I think they'd be wrong, and that's why I wrote the article to try and explain why they might be wrong. But ultimately, what their oath requires of them is faithfulness, and that they support the Constitution of the United States, and that means trying to get it right. Now, my concern is that I think a lot of these folks are not, have not thought these issues through very carefully and are responding in ways that are more guided by political interest. I mean, one thing that's been quite remarkable to me, even from groups like the ABA, is how much of their discussion of these issues is about why they think the ERA is good policy and not why they think this is the right understanding of Article 5 in the amendment process. It seems like the whole question should be the latter, not the former, because the ERA isn't any more likely to be part of the Constitution, whether or not you think it's a good idea.
You anticipated my next question because I was asking you about the obligations of the president and Congress. I was next going to turn to the obligations of the bar, and it is remarkable that the American Bar Association has taken such a forward-leaning position on this. So thank you for raising that. I hope we can all do better. I hope we do better here at the Society for the Rule of Law, and putting the Constitution first. I've got a bunch of questions popping up, so I will start posing some of the audience questions to you and maybe a few more of my own as we go.
Okay.
Um, uh, we have one question saying, okay, so we passed over rather quickly this idea about rescissions, and the question is not asking you to get in the weeds, but can you give a high level, just sort of gloss on what it might mean and what the implications are here for the ERA in particular?
Sure. So it really depends on what one thinks a ratification is. So Michael Stokes-Paulsen, in the article that I mentioned, General Theory of Article 5, suggests that a ratification is like a legislative action. So it's like passing a statute. And if you pass a statute, you can repeal a statute. And so Article 5 says that you need to be ratified by three-fourths of the states. And on that understanding, if you rescind your ratification before you've reached the magic number and it clicks, then there's the number of ratifications has gone down by one, and we have not yet reached the magic number. Another way of thinking of ratifications is that it's more like the House or Senate passage of a bill. It's more like a 52 chamber legislature that needs two-thirds votes in two of the chambers, the House and the Senate, and then three-fourths of the other legislatures to pass it by majority vote. And so when the House passes a bill and it goes over to the Senate, the House can't rescind that. They can't say like, I mean, sort of no fair takebacks. So in that sense, it's in the Senate's hands now. And if the Senate wants to pass it, it doesn't matter that the House now thinks it's a bad idea. So on that model, you might say once the state of Ohio or whatever passes, ratifies an amendment, it's passed through that chamber of the complicated 52 chamber legislature, and they can't take it back. And I find this question difficult. The text is mostly silent, so it really depends on what one thinks the context and the sort of implications would have been. That's why, to my mind, the cleaner and sort of easier way of understanding what's happened here is to note that even if it got the necessary 38 state ratifications, it still adds no text to the Constitution. Um, I think it would be a great idea if we amended the Constitution to make clear that rescissions before the magic number is reached are okay. But I don't see a groundswell of support for that position.
Because otherwise, you have this sort of odd one-way ratchet where, well, I guess maybe you could tell the story a little bit quickly about the 27th Amendment. You touched on it, but in a broader presentation, I don't know how familiar people are with it. It's kind of an interesting historical story.
Very much so. So in 1789, it's proposed as the original Second Amendment. It's the second on the list of 12.
Nothing to do with
Um,
guns.
Nothing to do with guns. It's about whether Congress can raise its own salary. And it says that they have to wait for an election before they can change their own salary, either in either direction. And so that was number two on the list of proposals. It was not ratified as part of the original Bill of Rights package. Almost enough states ratified it, but not quite enough. And then it just sat there for 200 years. And then one state did ratify it, and a college student wrote a term paper suggesting that it could be ratified by others and become part of the Constitution. And he got a C. And he got so mad at this that he decided to start writing to state legislatures and encouraging them to adopt it. And so single handedly, he managed to get this amendment ratified by three-fourths of the states. And then in 1992, it was accepted as the 27th Amendment to the Constitution. So, many people have said that it's a problem that once Congress proposes an amendment, it's out there forever. So there's the Corwin Amendment from before the Civil War that would have made slavery permanent. That's still out there for ratification. There's the Child Labor Amendment that's still out there for ratification, and so on and so forth. Titles Nobility Amendment. There are
Child
a
labor
variety.
amendment would have banned it. Right.
I'm sorry.
There was an anti-child labor amendment, just to be
It would have given
clear.
Congress power to
Yeah.
regulate child labor.
Pro-slavery, anti-child amendment.
Yes. And so, all these amendments are still out there for ratification, forever. And so there are different ways of dealing with that. One is to put a time limit in the way they did with the ERA in the initial proposal. We could also amend the Constitution to put in a 7-year clock, or we could amend the Constitution to allow for rescission. That way, everybody could sort of, get away from the slavery amendment and so on. There are lots of different possibilities there. But as things are currently set up, it's at least ambiguous whether there is any inherent time limit on an amendment, and the acceptance of the 27th suggests that there is not. There's certainly no time limit proposed in Article 5, and it would be very hard to identify one without such a textual statement.
We have one question just to clarify or to simplify the conclusion, which I think is pretty direct, but she's just simply asked, so is it correct to say that, into your view, the only way for the ERA to become part of the Constitution would be for Congress to repropose it and start from?
Yes. Yeah, the original 1972 proposal proposed to add text at a certain time, which has not and will never occur. It's as if they said, you know, this will become valid in a year that is both even and prime. That's just never going to happen. And so the result is if you want to add text to the Constitution, you're going to need a new amendment. And you've got to start all over with two-thirds of each House of Congress and three-fourths of states. And I think it's significant that even its advocates do not see that as a live possibility. I mean, I don't think its advocates even see two-thirds of each House of Congress as a live possibility, let alone three-quarters of the states, which means it would really be sort of imposing on the Republic an amendment that would not be supported today. Now, that doesn't necessarily push the legal argument one way or another. I mean, if it's valid, it's valid. But from a democratic perspective, I think we should be a little bit worried about that possibility.
Another question about the amendment process that grows out of this. Someone said a lot of the opposition to the ERA didn't seem to be to the words on its face, but worries about judicial interpretation, particularly in the 70s, activist courts and whatnot. How much power does Congress have to constrain judicial interpretation of amendments and how it frames an amendment?
Well, so in how it frames an amendment, it has immense power. It can write whatever it wants. Um, in terms of constraining the courts once the amendment is out there for ratification and once it's ratified, it has very little. So if the ERA says that you cannot deny equal rights on the basis of sex, and someone argues, as many people have, that that would require reversing Dobbs and restoring the rule of Roe. Indeed, that was one of the arguments that the ABA itself used as to why the ERA was such a good idea. There's not much that Congress can do about that because it would be part of the Constitution. And in any case that came up, I mean, Congress can take its own view of the Constitution for its own work in passing and, not passing bills, but it can't stop the courts from thinking that the Constitution is properly read a certain way. And so, to the extent that the courts need to weigh in on various questions, like does this doctor who performed an abortion go to jail under these circumstances? There's no way of taking the Constitution out of that question. So, and no way of taking the judge's understanding of the Constitution out of that question. So it's very, I would say that the more loosey-goosey approach to interpretation one has, the more difficult it is to pass amendments because the harder it is to get everyone on the same page about what this amendment will and will not do. That's one of the arguments that John McGinnis and Michael Rappaport have made for why the amendment process has really slowed down. We have not proposed and ratified an amendment in more than 50 years at this point. Because, in part, nobody can agree on a proposal, but also no one can agree on what a proposal would do once the judges get their hands on it. And that seems like a real problem for democracy.
How conscious in other amendment contexts has Congress been of this sort of problem? Have they tried to, develop legislative history, publish committee reports on the meaning of the amendment and how they, wanted it to see it applied? Is that a project Congress has been consciously engaged in, or not so much?
Sometimes, I mean, they often, I mean, when you're drafting an amendment, you have a greater degree of freedom to figure out exactly how you want to write it. And sometimes amendments or amendment proposals will have rules of construction in them. So they'll say, read this not to do X, but only to do Y, and so on. Um, but, as with legislation generally, it's not always easy to get everyone on the same page. So some kinds of amendments are very easy. If you wanted to increase the term of House members from 2 years to four, you can just say that, and there's not going to be a whole lot of interpretive disagreement. Maybe only about the transition and sort of its effective date, but not much more. But if you want to say, for example, Congress can regulate spending in elections. Well, there's lots of things that, might be thought to fall under that, especially if you are exempting it from First Amendment scrutiny. And so it becomes much more complicated to state the amendment. One of the reasons that Congress has not passed any effort to override Citizens United is because no one can really agree on how much power to restrict election-related speech they really want Congress to have. And so that becomes very difficult. Once the amendment is passed, there's not much Congress can do about it. And so that makes agreement much harder to achieve.
A question from someone in the audience about our discussion about the president's obligation to interpret or follow the Constitution. And the question was simply, if you accept a framework in which the president has an independent or equal authority to the court in interpreting the Constitution, how does that not open the door to an autocrat and
Right. So the obligation, just there's a question of what are the legal obligations of the president, and then there's a question about prudence and sort of political morality. So, as a matter of legal obligation, the president's oath is to the Constitution, and their job is to do what is necessary to take care that the laws be faithfully executed. And if the Supreme Court has gotten something wrong, that is a concern for them. Doesn't mean that they have to ignore it. There may be that the best way to take care that the laws are faithfully executed is to respect even an incorrect Supreme Court decision. So, for instance, if the Supreme Court has incorrectly stated that abortion laws are unenforceable, it would make sense for the president not to keep arresting people for violating abortion bans, even though on their view of the Constitution, that's correct, because they'd just be wasting everyone's time. You'd get to the district court, they would dismiss the indictment, and it would just impose lots of costs on people for no good reason. Whereas if there are circumstances where the best way to take care of the laws be faithfully executed is to produce a test case and to say, we read the Constitution this way, we think the court got it wrong, and we want the court to revisit that, then that might be the thing that the president is obligated to do. There's certainly the danger that the president might take a sort of motivated reasoning reading of the Constitution and say, I think it gives me all these powers. But then again, so could the Supreme Court. The Supreme Court could issue an opinion saying we're the nine emperors and we get to decide everything. And one reason they don't do that is because they expect that other people would say, thanks but no thanks. That maybe you can the judicial power means that your judgment is binding within your jurisdiction as to the parties before the court, but that doesn't mean that anything you say in your opinion is the Constitution. The Constitution and the U.S. reports are two different things, and I think that as the Constitution is currently constituted, as I read it at least, every actor and every officer has some obligation to think about what the Constitution actually says and not just what some other body, whether that's the president or the Supreme Court, says it says.
Prudence and political morality are two things that we desperately need and maybe
Indeed.
markedly, yeah, in short supply in our leadership class these days. Uh, we have, okay, so this is a question from a non-lawyer saying that, look, lots of blue states care about the Equal Rights Amendment. It's become a cause on the left. Uh, what can they do? Can they amend their own state constitutions? Can they, he specifically asked if, is there any ability to enter into multi-state compacts to advance the goals of the ERA, so long as they are not conflicting with federal law?
I would think so. So, certainly for their own internal constitutions, they can pass whatever ERA they want. Many of them already have done so. If they wanted to do it together, I don't know that an interstate compact would necessarily help, but they certainly could. If Congress wanted to approve such a compact, because of course under the compact clause they would have to. But you could certainly say, everyone who joins this compact agrees to abide by what the ERA would require of them. Congress could, by statute, oblige the United States to the extent that it was consistent with the Constitution to do what the ERA would otherwise have required. So all of this can be done by statute. The point of the ERA was to A, impose it on states in areas outside Congress's enumerated power that didn't want to adopt their own ERAs, and secondly, make it unrepealable by ordinary legislation. Those are the two things that you can only do by amendment that you can't do by ordinary statute, whether from states or Congress. And so, one question is, how much do we really need those things? How much does it really set back the cause of equality? Now, maybe it does under certain circumstances in certain states, or, on a Congress that might not endorse this for the long term. But I think that would be worth thinking about in terms of, what do the folks who want substantively what the ERA would provide, are there ways of taking half a loaf?
Someone's asking now, and I think this answer is probably clear, but it says, if we were starting the process over, would a new ERA be able to incorporate by reference previous ratifications?
I think the answer to that is no. And the reason is because every amendment has to be passed by two-thirds of each house and ratified by three-fourths of the states. So whatever states ratified the 1972 proposal, that was the 1972 proposal they were ratifying and not any other proposal, including one that has a different time limit. So if you wanted to have a new proposal with no time limit or with a different time limit, you would need to run the ratification process over again. In the same way that, the House having passed a bill 10 years ago doesn't mean the Senate can pick it up right now. Like that was that proposal, not this one.
You said that President Biden did not instruct the archivist to what is the term to
Publish. Yeah.
publish the amendment. And I don't know how much value there is in speculating, but what if he had? I mean, what if he had, and what if she? I believe it was a she at the time had
Yes.
agreed to do so.
Well, I will note, interestingly, she and her deputy wrote a statement saying that they thought that the ERA had not been validly adopted, which I think that the point of the deputy signing that, who has no particular role in uh, the process of publication, is to make clear that you would have needed a Saturday Night Massacre. You would have needed to fire the archivist. Then, the deputy becomes acting. You'd need to fire the acting, and so on. And that would be pretty controversial, I think, at least. Um, the process of publication doesn't do anything legally. A lot of people have had the view that once the archivist acts, the amendment becomes part of the Constitution. That's not true. I mean, there's no officer of the government who can just by their own fiat make something part of the Constitution or not. It's just a way of informing others of their view that this has satisfied all the prerequisites of becoming part of the Constitution. I think it has not. It has because of the time limit. It may have gotten 38 states as ratifications, but it did not actually make any change to the text of the Constitution, and so was not valid as part of the Constitution in that way. So I think that if the archivist had done so, that would not bind any other actor. It would merely sort of represent the relevant officer's view that this had been correctly done. But a court or Congress could certainly take a different view.
And maybe this is my last question. We're getting towards the end of the hour. Uh, there's another way to amend the Constitution, which is this convention idea, which is a bit of a cause on, I guess, on the right in recent years. Can you talk a little bit just about how that would work and maybe pluses and minuses to the idea?
Sure. So the Article 5 provides for two different mechanisms. One is that Congress can propose amendments. The other is that enough states can apply to have a constitutional convention, which would then debate on amendments, and then they would need to be ratified in the same way. It would sort of replace congressional proposal with a convention of states, but then you would still need ratification. Now, it is arguable whether, in fact, enough states have done this. Michael Stokes-Paulson goes into the argument in great detail in that piece I mentioned. Um, but part of the concern is whether you can call a limited convention. So suppose we wanted to have a convention just to consider a balanced budget amendment. Well, you could certainly say we would like you to consider a balanced budget amendment, but it's not clear under Article 5 whether you could limit the convention to just that topic. And there would be then other kinds of questions, not legal ones, but political ones, of what would happen if that convention, like the one at Philadelphia, exceeded its mandate and proposed all kinds of things. And then that went through the ratification process. And I don't think anybody has any idea what the upshot of that would be. And so one reason that we haven't gone through the convention process is that no one knows what would come out of it. And everyone is scared that it would be something they really wouldn't like. And one proposal I have made is that instead of having this sort of convention process that could come up with anything, have, in a sense, a rolling convention. We could amend the Constitution to allow an alternative route whereby states propose amendments and Congress ratifies them, and make that just another route in addition to Article 5. And what that would mean is that a proposal could sort of bounce around the states and get refined in that way. And once three-fourths of the states had all signed on to the same language, then Congress, by two-thirds of each house, could ratify. And that would make it a little easier for sort of new amendment ideas to come to the fore, but it would not change the threshold of needing three-fourths and two-thirds, or, in one order or the other. So I think that the convention possibility is a possibility, but I think the very fact that it's unlimited and that we don't really know whether limits would work or not, whether legally or politically, makes it much harder to do than something where we would let the states go first, but they need to agree on a single text.
Thank you so much, Professor Sachs. Do you have anything I didn't ask you about, or just kind of closing thoughts you'd like to give us on either the ERA itself or the Constitution, the amendment process?
So I think, this is an era where people disagree very fundamentally about the law. And I think that that is at the root of a lot of our other debates. The debates over Supreme Court reform, over, all sorts of other things really are just sort of proxies for underlying debates about how to understand the law. And I think that, to the extent that we can have agreement, it's a very important thing. And that muddying the waters on what the Constitution says is not to be preferred. And to be clear, ultimately, people need to argue for the position they think is right. If they think the ERA really was validly ratified, that they should say so. I'm not saying that the folks who have made that argument are being in any way disingenuous, but I am saying that such arguments need to be made carefully and with an eye to the process and not to the outcomes. And unfortunately, I'm not sure that that's how the argument has gone thus far.
Thank you so much. Was really a great article. We're dropping the link again. It's a really good read. It was a terrific, concise presentation of the article as well. We really appreciate your time. Again, I mean, I think this is it's interesting on its own terms, but it gets to a lot of deeper questions about the law and the Constitution, and which we try to take seriously here by putting principle ahead of outcomes, which I think is there's a lot of motivated legal reasoning that happens on both the left and the right these days. So it's important to have conversations that uh, take serious principles and are clear-eyed about the dangers of not doing so. So thank you so much for being part of our conversation today, Professor Sachs. I really appreciate it. Again, to everybody, we are a membership organization. Our members make this possible. If you're interested in membership, please join up at our website. Please also follow us on social media. We are on Twitter, Blue Sky, and YouTube and LinkedIn. So you can keep track of our upcoming events there. We have several that we will be announcing in the coming days. So I look forward to seeing you all online and in person soon. Thank you again, Professor Sachs. Enjoy summer in New England. Hopefully the weather is warming up there.
Yes, thank you so much.
Thank you. Take care.